Good afternoon. This is Jeremy Dawson from the NAST headquarters in Lexington, Kentucky, and I would like to welcome you to today's webinar on issuer considerations, bank loans. The slide deck we are presenting is available for your reference in the handout section of the GoToWebinar platform, along with bios for our speakers, and the slides will be available along with the video recording in the webinar archive of the NAST and SDMN sites. Please note that you are free to submit questions electronically via the webinar platform during the presentation, and these will be addressed by the facilitator during today's webinar. So to electronically submit questions, you simply type them into the questions dialog box on your GoToWebinar application. So let's make sure that everyone is awake and knows how to submit questions. Please type in how many people in your office you have currently tuning in. Okay, we're starting to get some responses. We got 2. Another person has 2 in their office. Just got someone watching solo, another duo here. All right, well, it looks like everybody knows how to use the application, so that's wonderful. We encourage you to take advantage of that. Very quickly, I would like to encourage everyone to attend the Treasury Management Training Symposium in May. SDMN will be hosting a track of 12 educational sessions alongside banking and cash management, financial education and empowerment, college savings, and unclaimed property. And the hotel block closes on April 17th, so visit the NAST site to learn more and register. And with that brief commercial out of the way, on behalf of NAST and SDMN, I would like to welcome and thank our speakers for presenting to our membership today. And Mr. Erdman, at this point, I'll turn the floor over to you.
Thanks, Jeremy. And thanks to everyone for joining us today on the State Debt Management Network webinar on the topic of bank loans, issuer considerations, organized by the Webinar Committee of the State Debt Management Network. I'd like to first thank our speakers who have graciously given us a great deal of their time to deal with prepare this presentation. Peg Henry joins us from Stifel Financial Corporation. Peg is the Deputy General Counsel of Stifel, where she's responsible for all legal matters concerning the Municipal Finance Group. Peg has an extensive history in the regulatory area, where she has served as General Counsel for market regulation of the MSRB. She's been an attorney advisor for the Securities Exchange Commission. She's been an attorney advisor to the U.S. Department of Treasury. And she's also served as in-house counsel for the municipal securities groups of Jefferies LLC and UBS Securities. Thanks also to Renee Boicourt, who's the managing director and partner of Lamont, where she's been at since 2006. At that time, she's advised large states such as Connecticut, California, Louisiana, and Wisconsin. She's also advised creditors regarding Jefferson County, Alabama, Detroit, Michigan, and Puerto Rico. Prior to joining Lamont, Renee was the managing director for high-profile ratings at Moody's Investor Service, where she chaired ratings committee meetings at Moody's for many of the market's most complex and significant ratings. So thanks to both of them for giving us their time this afternoon. I also want to thank my co-moderator, Ellen Evans from the state of Washington, and thanks to the NAST staff for preparing all the logistics and advertising for this webinar. Before we start, I just want to highlight that the State Debt Management Network Webinar Committee is looking for ideas for the remainder of calendar year 2017. If anyone has an idea they would like the Webinar Committee to address, feel free to submit that to our contacts at NAST or submit them to myself directly, David Erdman at wisconsin.gov. Jeremy talked about how the questions are to be entered during this webinar. We encourage people to enter questions as we go on. We will have a short stoppage in between different sections of this webinar, which will address questions that have come up thus far, and we'll also address general questions at the end of the presentation. And again, in addition to all the thanks I've given, thanks to every one of you for participating in today's webinar. With that, we'll go to the introduction slide, slide 2. This webinar is going to address many facets of bank loans and discuss regulatory, credit, benefits, challenges, and other considerations at state level and large issuers need to be aware of. Bank loans continue to be an important financing option for municipalities. They've been around for approximately 6 or 7 years, probably had their highlight in 2013 and 14, but continue again to be a tool for issuers' tool chest, and also a mechanism in which investment bankers that cover states can use their associated bank and the bank's balance sheet to help out issuers in time of need for capital projects or refundings. The exact number of bank loans is difficult to tell, and part of our presentation will address terminology as to what exactly are bank loans. But in 2013, Standard & Poor's actually estimated that up to 20% of new market issuances were taken in the form of bank loans. Not sure if that number is accurate, but I think it's come down from that as bank balance sheets have changed over the years. But again, a big tool that's being used by municipalities and banks to help with capital financing. Some of the early slides, like I mentioned, will address terminology. Some of the other early slides will address regulatory structure that currently is unsettled. With that, I will turn it over to our speakers for the rest of the presentation.
Okay, could we go to slide 3, please? First thing I would like to note is that this webinar is very timely because tomorrow the SEC is going to have an open meeting at which time it is going to discuss proposed amendments to Rule 15C212. That's the rule that requires certain events and certain documents to be filed with the MSRB when you do a securities transaction under your continuing disclosure agreement. And there is considerable speculation that what they've announced, this is the agenda item on your slide, they've announced that the Commission will be considering adding 2 event notices to the list of events that have to be disclosed under 15C212. It is expected that one of those will be bank loans, and that the other one is unclear whether it's other debt obligations or whether it's private placements. No one's quite sure what the other event notice will be at this point. But stay tuned. You know, that will come out at some point tomorrow. It's going to be broadcasted live, so look to the bond buyer and other outlets to see what's presented. Okay. Could you go to the next slide, please? One thing that we wanted to do before we get into further discussion is to talk about what kind of terminology, what we mean by various terms that we're going to use during this webinar. The first is, what do we mean by bank loan? And that is an actual loan from a bank to a government that is not a security. And I'm going to be discussing the difference between what is a loan and what is a security. The other terms sometimes used are direct purchase or direct placement. In this case, we're dealing not with a loan, but with the security of a government that is purchased by the bank or another investor in a private placement. Could we go to the next slide, please? Okay. The players in these transactions differ depending upon whether or not you're talking about a loan or a direct purchase. If you're talking about a loan, you obviously have the government, then you have the bank. You may have an advisor who's giving the government advice on negotiating with the bank. Then the bank will have their own counsel, and then the government may have its own an attorney representing it on the transaction. When you're dealing with a direct purchase, obviously once again you have the government, then you have the bank, or you might have another type of investor besides the bank who's interested in purchasing the security and the placement. You once again may very well have your municipal advisor, although the role of the municipal advisor in this transaction may differ than its role in connection with a bank loan, as we'll discuss later on. Then you frequently will have bond counsel, and you may or may not have a placement agent. Can we go to the next slide, please? So why do we care what's a loan and what's a security? You know, from a regulatory standpoint, there are significant differences. First of all, if it's a security, all the federal and state securities laws apply, whereas they do not apply to bank loans. So, for example, from the standpoint of the government, one of the key elements is that if it's a security, the anti-fraud laws apply. So if it's a security, you must make complete and accurate disclosure to the investor, or else the anti-fraud laws may come into play. If it's a bank loan, those anti-fraud laws do not apply. Also, securities transactions must be reported to the MSRB, and continuing disclosure rules apply, whereas those kinds of rules do not apply to bank loans. The MSRB and the SEC do not have jurisdiction over bank loans. Third, your financial advisor may not help you place a security, and under both MSRB rules, and there are also some actual broker-dealer registration questions that come into play. Now, what do I mean by placing a security? The limited guidance that the SEC has given in this area looks to who goes out and solicits the investor, who negotiates with the investor, right? Those roles are indicative of a placement agent, right? And also the factor that the SEC has looked at is whether that same person receives transaction-based compensation. So if your financial advisor, and those same factors would be relevant to whether somebody's acting as a broker. So if your financial advisor is the one that's actually going out and soliciting investors and negotiating with them, and it turns out that you're dealing with a security rather than a loan, your financial advisor may have become an unregistered broker-dealer. Whether or not your financial advisor is already a registered broker-dealer or an independent financial advisor, MSRB Rule G23 may come into effect. And G23 tells a dealer that they may not be a financial advisor and a placement agent on the same issue of municipal securities. So understanding that distinction is very key. Lastly, the municipal advisor rules apply to advice on securities, not to advice on bank loans. So the MSRB, both the SEC rule on who is a municipal advisor and who's not, and also the MSRB rule G42 apply to advisors giving advice on securities transactions, but not advice on bank loans. Okay. Could we go to the next slide, please? So there's not a great deal of guidance that is really applicable to municipal securities transactions on what is a loan versus what is a security. The SEC tells us that we should be looking at the leading Supreme Court case on this subject called Reeves versus Ernst & Young, and apply those factors that were analyzed by that court to municipal securities transactions, although Reeves had nothing to do with municipal securities. The first thing that the Supreme Court said in Reeves was that if a loan is evidenced by a note, it's going to be presumed to be a security, all right? So many loans are evidenced by notes. So right there, you may frequently find yourself in a position where you're starting out with a presumption that something is a security and you're having to rebut it. So in the Reeves case, what they said is that there were exceptions. Even though there is a note, you may still conclude that what you're dealing with is substantively a loan. And the ones that they gave are consumer financings, home mortgages, small business loans, accounts receivable, and loans for ordinary operations. Well, you may say, how many of those really apply to municipal securities transactions where we're trying to finance an asset? So if you could go to the next slide, please. So the court in Reeves said that loans bearing a strong family resemblance to the loans on the previous slide are also not considered to be securities. And the key factors in the family resemblance test are, first, the motivations of the buyer and seller. Second, whether there is a plan of distribution. That is it just going to be held by the investor, or is it going to be distributed more broadly? Reasonable expectations of the investing public of an alternate regulatory regime. So let's go to the next slide and see how those factors are interpreted in the context of a municipal securities transaction. So the court said, as to the motivations of the buyer and seller, they said, are you financing substantial assets? And if you are, that looks more like a security. If you're simply correcting cash flow difficulties, on the other hand, that looks more like a loan. So many of you will think, well, we already have a note, so we know we're already behind the 8 ball on that one, because that creates a presumption of security. And in many cases, we're financing a long-lived asset. So in effect, we've already flunked the first test, the motivation of the buyer and seller. So that means that it's really important to make sure that you pass all the other tests in the family resemblance test. Passing these tests would be indicative of a loan. So in the second one, the plan of distribution, a QSIP indicates that a note is likely to be traded and is likely going to be considered a security. The lack of a QSIP is more indicative of a loan. That is, it's not likely that it's going to be distributed beyond the bank who's purchasing it. Next, reasonable expectations of the investing public. Is the note called a bond, or are loan documents used? It is not a helpful fact for the instrument to be called a bond. Now, you may have issues with the way that your resolutions or your trust indentures are drafted, and they may not provide for the issuance of loans. They may just provide for the issuance of bonds. One of the things that FINRA does when they examine in this area, they look closely at what these things are called, and if something's called a bond, the dealer that, or the municipal advisor that they're regulating is going to face an uphill battle. So it's much preferable to use loan documents. Second, are loans legal under state law? In certain states, it's not legal for a government to enter into a loan. So that would be more indicative of a security. And finally, the existence of another regulatory scheme. In the case of banks, federal banking regulators regulate their loans. If it's another type of investor that's not a bank, there may not be an alternative regulatory system that would regulate that lending activity, and that would be a factor that the courts might consider in saying, well, since there's no alternative regulatory system, maybe we should treat this like a security, because then at least in that case the SEC will regulate it. Okay, let's go to the next slide. Now, I know I've given you a lot of information today about this topic, and there is a lot more to be said about it. There is actually a very good source document that you can look to that goes into this really in the context of municipal securities, and that is this MSRB notice 2011-52 from September of 2011. That goes into all of what I just described, and it can serve as a good reference material.
So Peg, this is Ellen Evans. If we could take a break here. Thank you for the presentation on this material. I have a couple questions, both of my own and some that are coming in from various participants in today's call. Step back through this loan versus security discussion and think about it from the perspective of an issuer who is thinking about, rather than going to the bond market, who is thinking about either a loan or a direct placement. And they are used to working with their municipal advisor. I'm looking at the players list now. And they think, maybe we don't want to do a bond. Maybe we want to do something else. My question is, there's several layers of questions. The first is, who is really going to determine if this is a loan or a security, and when in the process does this happen? It seems to be very complex. It seems to determine, the answer to that question seems to determine how you can talk with and work with your municipal advisor, and how do you even know this when you're starting out?
Okay, well, the way I look at it, there are at least 4 parties involved, and they may each have different perspectives on whether something is a loan or a security. There's the issuer, there's the bank, and there's the municipal advisor. Possibly the law firm may have a view on the subject. From the perspective of the issuer, the reason they care is, because one, they have to make sure that if it is a loan, they have the authority to enter into a loan under state law, and they'll consult with their counsel on that subject. They also need to be aware of whether or not it's a loan because whether or not the securities laws apply, the anti-fraud laws that I just described. So they may have a view on that subject, and that's why it's important to them, and they'll consult with their counsel, and they'll look at their authorizing documents. The bank has a view on the subject because how they book the security will determine whether or not they have to market to market. If it's a loan, they don't have to market to market. If they book it as a security, they are going to have to market to market, and they have to deal with their own banking regulators as to which is a more appropriate categorization. So banks may say, well, I don't want a CUSIP number, and that may be because a CUSIP number would make it less likely that they can book it as a loan under their own regulatory scheme. Now, the municipal advisor is sort of caught in the middle in the sense that they have to beware that they don't wind up serving as a placement agent for a security that's just happens to be purchased by a bank, because as I said before, if it's an unregulated, if it's a municipal advisor that's not already registered as a broker-dealer, they may find themselves characterized as an unlicensed broker-dealer, right, and subject to regulatory fines and penalties as a result of that. Even if they are a registered broker-dealer already, they may find themselves having violated Rule G23. So a couple of things may happen, and it may be driven by the concern of the municipal advisor as to regulatory penalties that may be imposed on them. So, for example, if one thing your municipal advisor may say is, well, we're really not sure, whether this is a loan or a security. The bank is unwilling to say in writing that they're going to book it as a loan, for example, or the bank is requesting a CUSIP number, and so the municipal advisor says, wow, well, those are factors that are not particularly helpful. And then we find out it's being done under a resolution or a trust indenture rather than loan documents. So the municipal advisor may be understandably nervous. So they may say to the issuer, you know what, we can avoid our regulatory problems by having you, the issuer, be the one who solicits the investors, or you, the issuer, be the one who actually negotiates with the bank. And therefore, the municipal advisor is not going to be characterized as a placement agent and can avoid those regulatory concerns. If you already have a municipal advisor that's a broker-dealer, they may decide that they think that they need to report the transaction to the MSRB if they're going to be involved in the negotiations at all, because they think that that's the broker-dealer MA can't be involved in the negotiations either, because then they would have a violation of Rule G23. So it's really going to be a matter of discussion among the various parties. If they're really concerned that it's a security, the municipal advisor might also suggest bringing in a separate placement agent to be involved in the transaction. That's why I listed in the players earlier, I had placement agent in brackets. because that's also another potential may be structured.
So Peg, Ellen Evans again, let me, two follow-up questions on that. The process that you're describing suggests that there would be fairly significant conversations, discussions with potential providers of this obligation, whether it be characterized as a loan or a direct placement of security, so that you would speak to a number of folks and get a sense of how they tend to view them, treat them, and then you could determine the roles of the various folks on your team. And the second follow-up question would be, if you do determine it's likely to be treated as a security, who are the placement agents then? Who would you look, if you don't want to do it on your own, who would you look to be a placement agent?
Well, it would be a broker-dealer, a registered broker-dealer, and it could be somebody who sometimes serves as an underwriter. It could be someone who only serves as a placement agent, but many underwriters also do placements. So it's usually someone of that nature that would do it, but it has to be someone who's a registered broker-dealer.
Excellent, thank you.
Peg, this is Dave Erdman. Quick question, I think this is now a good time to bring it up. A lot of states have SRF programs in which they make loans to local governments in their state. These are loans going from the state to a local government. In Wisconsin, we get a obligation back to evidence that loan. Is there anything in the regulatory schemes that address situations like that? I mean, are we creating or making loans to local governments in which local governments have to be concerned that now they have a loan and have to do certain things because they have a loan, as using the terms that you've defined?
Well, there is, in that context, there is a special rule in MSRB Rule G23 that deals with a situation where a municipal advisor is advising one of those local governments who wants to borrow through the SRF pool. In some states, those loans are evidenced by bonds, right? And so the question has come up about whether the municipal advisor for the local government can also assist the local government in dealing with the state SRF. And because there's a bond that's going to be issued to evidence the loan, does that cause a violation of G23? And there's actually a special provision in G23 that says as long as the municipal advisor doesn't get a separate placement agent fee, that is, they only get paid for their municipal advice, then that's an exception to Rule G23 and it's not a violation. I think there has been some discussion that I've heard about with the securities regulators, and they really had not foreseen that those local governments would need to worry about that bond that evidences a loan and whether or not that has to be, subject to the anti-fraud laws and all that. While you may make a theoretical argument that it could be, I don't think that the SEC at least is focused on the obligations of the local government to the SRF. Now that there's a bond evidencing it. In fact, I understand that this question came up to one of the SEC enforcement people at a conference a few months back, and they are not focused on it. Theoretically, I guess the same issues could apply.
Okay, thanks. With that, I think we'll go to the next slide.
Actually, could I go add on one more question that's come through, and that's going back to slide number 9, looking at the motivations of the buyer and the seller. Again, is it a loan or a security? If the financing of substantial assets, if that's what you're doing with this obligation, if that indicates it's a security, wouldn't that suggest that nearly all of the borrowings, be they initially considered as bank loans or direct placements, would in fact be securities and would need to be regulated and placed as such?
Well, as I said, you've got a note, so that indicates a security, and then you've in effect flunked this first test. because you're financing something that would indicate a security. The general thinking is that if you can pass all the other tests, then people will be okay with treating it as a loan. But at our firm, we have an additional thing, and we require the bank to tell us in writing that they're going to book it as a loan. I want to say that in most cases, our firm ends up treating these types of transactions as securities because we think that there's enough gray area, and that we're taking the conservative position from a regulatory standpoint. But it is possible that if you pass all the other tests, there's no QSIPs. It's being done pursuant to loan documents. It's not being called a bond. It's legal to make a loan, to enter into a loan under state law. It's with a bank, that people can get comfortable that it is going to be treated as a loan and not a security.
More gray area. Thank you, Peg.
Okay, I'll jump in. This is Renee Boicourt, and I'm going to talk about how these bank loans might be used as one of the items on the menu of borrowing options for issuers, and talk first about the benefits and then the challenges. Just real quick, I'm on the MSRB, but I'm not speaking as a board member. This is just speaking as me. So if you could move forward to the next slide. Thanks. So starting with the benefits, the first most obvious benefit is just the cost of funds, a low interest rate, and I think that's what draws most issuers to this part of the market. As Dave mentioned, the numbers I think got up to at a peak of 24 billion, something like that. So it's a very substantial part of the market. Came down a little bit in the most recent year. Data is a little soft on this. We see, in particular, in the either short on the yield curve or floating rate, the bank loan market is particularly competitive. But the fixed rate loans can also find a lower rate, particularly when you're talking about a smaller transaction. The second advantage is transaction costs. You can avoid a number of costs, such as the underwriter's takedown, remarketing agent, and if you were considering doing a floater that had to be remarketed, rating fees. One expense that you can't avoid, and if what we just heard reinforced, is that you need to have a good attorney with expertise in this area. Odds are you have somebody like that on your team if you've ever done standby. So there's the cost of funds and the transaction costs. The other burden that we should talk about is disclosure, and it is lighter than in a public offering, the complexity of the regulatory environment notwithstanding. You may be aware that the MSRB went through a process recently over the last 6 months or so, considering various options of what it might be able to do to respond to sort of investor clamoring for more information on the bank loan market. And then, of course, we have the SEC now stepping up tomorrow to talk about adding bank loans potentially to the list of material events. But even if that's where it lands, the disclosure on a bank loan is likely to remain easier than pulling together a POS for a securities market transaction, especially in certain circumstances. For example, issuers find themselves from time to time in a period where they need to fund, they need cash flow for the capital plan, but they're at a particularly eventful period in their financial cycle, and it's difficult to put a POS out there that doesn't all of a sudden get stale. I think Many of us have been in that position where you just printed a POS and then something important happens and you have to decide whether or not it requires you to sticker and run through that drill. So a bank loan doesn't entail that same process. If those are the circumstances, one thing that might work well would be a bond anticipation note as a bank loan. And the banks do play that role quite a bit. And that could be used to give you a bridge to a quieter period when maybe the dust has settled on some of the uncertainties. Let's turn to the next page. Another aspect of the bank loan route is that you don't need to get ratings and you save the time and cost involved in that. Sometimes banks will ask for a rating affirmation, but you can typically negotiate that down to just a confirmation that the rating is still, on the rating agency's website as the rating that it is. Another aspect of ratings is that you may, if you're dealing with a new security structure that you haven't offered before, you may face a fair amount of uncertainty on the rating outcome, and it just may be more expedient to just negotiate directly with the bank about the risk as opposed to the rating. And then another aspect of this is that from time to time, the bank actually takes a more favorable view of the credit risk than the rating agencies. This comes up in some of the areas where rating agencies have changed their criteria recently to be more conservative. For example, special tax bonds. Some of the rating agencies have those capped at the GEO rating with rare exceptions, and some banks continue to see some special tax bonds, gas tax bonds, for example, as better than the GEO in certain instances. And so you can get the benefit of that view of the credit as opposed to being kind of held by the rating in the public debt market. And then finally, we do see bank loans for acquisition financings, especially for hospitals, where the risk, to properly assess the risk, you sort of have to look at the business plan, and a lender knows how to do that, and they're in the business of doing that, whereas rating agencies have a little trouble doing that and tend to rate acquisition-related financings more conservatively than a bank's cost of funds would suggest they should. Another advantage is that it is possible to get somewhat more prepayment flexibility under a bank loan in some circumstances. The floating rate note market, FRNs, index floaters, a fair number of issuers got into that market 3 or 4 years ago when the rates were quite favorable. And in the public market, typically you would negotiate say a 3-year note with a mandatory tender. You could maybe get a call 6 months in advance, but with a bank you can often negotiate a call that's more flexible than that, shorter than that. And similarly on the fixed rate side, you may have to have a premium for a prepayment, but that premium that you would have to pay a bank could very well be less than the premium you would pay in the public debt market for a call shorter than 10 years. Those tend to be fairly expensive in the tax-exempt market. So turning to the next page, please, let's shift to the sort of challenges side of the equation. The first one is price discovery and ensuring that it's a competitive process. And this involves both process and substance issues. A lot of this is framed by the procurement rules of a particular jurisdiction, and we do see issuers doing this through a formal solicitation process, and think that is useful. among the first steps, of course, is to be in a position to compare the bank loan costs to your alternative of going to the public debt market, and your municipal advisor can help you with that and give you an analysis of the rates at which you would likely price in a public deal. And then via your RFQ or RFP, you can solicit indicative pricing for fixed rate bank loans, and then for floating rate bank loans, you can solicit actual quotes as spreads to an index. If you do a solicitation like that, we find it's useful for the issuer to actually control the term sheet and to include a term sheet as part of the RFP with the terms the way the issuer wants it. And then the responses you get are apples to apples, and you can compare the interest rate. And then simultaneously, also in the same RFP, invite the proposers to offer an alternative structure where they may depart from your term sheet and want certain other terms, and then that'll surface what those are worth to you, basically, the degree to which those might actually improve the interest rate if you relaxed your sort of baseline term sheet a bit, and that will inform your decision. Another approach is to actually solicit for the bank loans at the same time that you're soliciting for a traditional underwriting, to do a standard broker-dealer underwriting RFP, but then also have a section in the RFP that invites a broader collection of financial institutions to make proposals that address the need as you've defined it, and that will bring in proposals for bank loans. One of the challenges with the fixed rate deals is that you're only getting indicative pricing, and the lender is, of course, going to reserve the right to change the rate up to a certain point where then they will lock it. And if they've set it relative to an index, that's fine. That's similar to the risk you face when you're going into the public debt markets. You know the underlying bond market is going to move as you get closer to your pricing. But often the lender has kind of a secret sauce for their interest rate, and it's not that transparent to you. So one approach is to narrow the prospective lenders down to a short list of 2 or 3, even 2 works, and then spend a little bit of time homing in on the legal terms to make sure that you really are agreeing on the same term sheet. And during that time, refresh the indicative pricing. And even in some instances, it's useful to kind of keep in your hip pocket the option of going into the public market, because that will make the lender understand that you do have an alternative, that you're not only going to go with a bank loan or nothing. And then often your MA can sort of reverse engineer what's really driving the cost of funds and prevent you from being hit with a surprise out of the blue of having the ultimate rate that they commit to be wildly higher than the rate you were expecting. And it's possible to bring that uncertainty down within the range that you would expect for a public debt offering, where, of course, how you price has to do with a lot of things, but one of them just how the market is on the day you're in the market. The bottom half of this slide we've really talked about a fair amount already. I guess just to add to the earlier discussion, we think that the practical way to do this is just go into the process on the assumption that it is a security. And because, as Peg discussed, the test for it to be a bank loan and not a security really is difficult. And when you do a solicitation, you may very well surface proposals for things that are securities and find that those are the best cost of funds. And so you wouldn't want to try and rule that out at the outset by having a process that made that too complicated. And so it's better to just go into it expecting to manage that regulatory environment. And as Peg explained, it means that the issuer really has to be, in the driver's seat and can't delegate much, as much as they might under a public market offering. So it's more work for the issuer. And then the compensation structure for the MA cannot include any contingent fee, and it has to be, hourly or retainer or something that, where they don't. It can't be a situation where they only get paid if the deal closes. And I think that particular aspect of the regulatory structure is important. The MA, of course, can advise you, but they cannot negotiate or place the instrument. Moving to the next page, let's talk about some of the nitty-gritty of what you'll encounter in documents. Whenever I see a term sheet that the bank has said is going to have customary covenants, I always make sure of asking what exactly those are, because there are different views of what's customary. But two that you will almost certainly see that aren't great from the borrower's point of view are the right that the bank retains to pass through costs, if they change, related to two things. One, the tax rate, and here they have in mind the corporate tax rate, because that's what they're sheltering against, if you will. And then the other is regulatory changes that affect the bank's cost of capital related to bank reserve policies for different kinds of loans, for example. So in both these instances, the language allows them to raise your interest rate in the middle of the deal, or widen out the spread if it's an index floater, to protect the bank or compensate the bank for these increased costs. Now, if you talk to the banks that are active in this business, they will say that it's never happened that that in the public finance business you won't find a case where one of these covenants was actually triggered. It's hard to prove a negative. I haven't been able to find a case where that happened, but that doesn't mean it hasn't happened, particularly on the part of a regional bank or a smaller bank that it might not have gotten a lot of news. So what can an issuer do to protect itself against these covenants? Well, first, an issuer's attorney can ask the bank to give the issuer require the issuer to give you a calculation certificate of some sort where they show you the math of how they calculated this extra cost. And the issuer's counsel should also ask to have a consent right on that pass-through. You probably won't get it, and you'll probably end up compromising at, a soft consent where the issuer can't unreasonably withhold the consent. But it will, I think, make it more transparent if it happens, and make it harder for the bank to do it in a borderline case. But the second and a way better, more effective protection against these provisions is just to have the right to prepay if the bank exercises one of these rights to raise your rate, and that's pretty clean and simple. And banks have shown some willingness to do that in this market. Let's turn to the next page and shift gears a little bit. So we've been talking really about things from the issuer's point of view, and here kind of stand in the shoes of the investors for a minute. As this market sort of took off a few years ago, we heard a lot of concerns on the part of the buy side, credit analysts, and also rating agencies. And a lot of complaints. My view is that, in fact, the issuer's interests and the investors in the public debt interests are actually pretty well aligned here. Odds are you're going to go back to the public market. You're not going to rely on the bank loan market forever or exclusively, and certainly most state issuers have developed a pretty good pattern of disclosure and communication with their investor community and want to maintain that level of trust. And so, you know, disclosing the transaction, I think, is in a issuer's interest. The thing that the investors are really focused on is if the bank loan is supposed to be parity to the bonds that are already held by public investors, well, just what exactly does that mean? And they want to be very sure that the lender hasn't gotten extra security features, either in the form of their actual security, like a mortgage or lien, or, and more importantly, they're very focused on remedies that the bank has in the event that something goes wrong, where the bank can force the issuer to, where the bank can accelerate the debt, or have it be all due and payable now, today, tomorrow, or require that it term out over an accelerated schedule. We often see 3 to 5 years. Here, a couple of ways to go. One is if you're reasonably, if your expectation is that there's probably going to be a fair amount of interest in making this loan, that that it's a good credit. There are a number of players who are interested. Your term sheet in your solicitation can just simply say no. Just, we won't do it. We won't accelerate, and that's the simplest solution. Alternatively, you can see if it's possible to pivot away from acceleration or a term out, and instead have a provision where if there's an event of default, your rate just goes way up and is very, very high, and higher than you would have to pay in the public market. And from the bank's point of view, that'll drive you to refinance as quickly as possible, which, after all, is what they want to have happen in an acceleration situation as well. As you know, rating agencies and investors don't like bullet maturities, puts, rollover risk, all that kind of stuff. And I think issuers can manage that here in the bank loan market, really in the same way that you do it in the public debt markets, which is to have a plan for the refinancing or for paying the maturity. And one of the key elements is to have flexibility to prepay. If you haven't already succeeded in getting a very open-ended flexibility to prepay, banks will typically agree to a 6-month window, for example, and the issuer can get itself organized to take that refinancing to market, or potentially renegotiate another bank loan, or roll it with the existing bank. Whatever it is that's going to happen, leave yourself some time so that if there is a rough patch in the public debt market, you can sit it out for a few weeks and still have time to execute your public market deal before you run up against the brick wall of your mandatory redemption on the bank loan or the bullet maturity in some cases. So with that, I think perhaps we want to stop here and field questions, or the next topic is the GFOA best practices.
So Renee, yes, thank you for this material. You've given us lots of ideas as to how to approach a potential loan or security direct placement situation, lots of business points. A couple of follow-up questions. As issuers, most of us know who the underwriters are, we know who the banks are, we know who participates in either negotiated or competitive sales. We're familiar with those players. I think we're probably less familiar with who might be interested in a loan or a security in this type of direct placement. And that said, but it's still to our advantage to have as many prospective lenders involved in this process and interested in thinking about our situation as possible. So how do we know, particularly if we take your advice and think that, this is probably going to be a security and I'm not going to be able to use my MS as a placement agent, how are we going to know, and what would you suggest to maximize the bank participation in a prospective lending situation like this?
So you can start with the banks that are active in the liquidity facility market, because most of them are also active here. The other suggestion would be to call your colleagues at large issuers that are in this market a lot and have relied on bank loans. Your MA can help you develop a list to whom you're going to send the solicitation. The solicitation will come from the issuer, not from the MA, and that's important. But the MA can certainly advise you, and most MAs have a working list of the banks that are active in this market.
All right, that's very helpful. Do you, I know that, or my sense is that the market has continues to develop, and perhaps that we're seeing longer terms than we used to, banks engaged in lending for longer periods of time. Do you have any even anecdotal sense of how far out banks are willing to lend these days, and whether that's on a floating rate or a fixed rate basis?
Sure. So on a floating rate basis, the index products, they'll go out to 5 years. It starts to converge a little bit on the public market when you get that long, but a little shorter, 3-4 years, the pricing is actually quite a bit better than the public FRN market right now. I think there's a similar dynamic for large issuers, liquid names with high ratings and so forth. The longer you get, there is sort of a convergence on the public market. But I do see indirectly, not in our immediate client base, but indirectly for smaller issuers, a willingness of regional banks in particular to lend, even 20 years, which didn't used to be a place that commercial banks tended to play. But I think, I do think it's key to, to explore this cost relative to your public market options, and sort of start there. And we went through sort of the pluses and minuses of the device, but always keep your eye on the ball of cost, of course, as I'm sure you would.
Right, right. One last follow-up question, and I know there may be some from others as well. You've mentioned that the interests of issuers and investors or credit analysts, the buy side, may be aligned, but there certainly has been tension there in the past many months, in which some credit analysts and rating agencies have complained that issuers have not provided adequate information to the public market about what's going on, and so there's anxiety or some nervousness about additional parity debt, or even in some cases bank loans hopping in front of the publicly traded debt. Have you seen? So certain issuers have taken the action to disclose their loans or many of the terms of their loans on an EMA or in some other widely available website. Have you seen any, I want to say blowback, but any sort of negative response from credit analysts or from rating agencies when they've learned of the loans that are on issuers' books?
So I haven't directly. I should have mentioned that, with respect to the rating agencies, it's wise to let them know you're doing it in advance. Sort of a keep your enemies close strategy, if you will, just so that they're not surprised if it hits the bond buyer, or hits Emma. I think the buy-side analysts always want more. If you look at the National Federation of Municipal Analysts, has a best practices for bank loans, and is probably the loudest one, always crying for more disclosure as a general matter, and one can understand their frustration. But they're probably never going to think you're doing enough disclosure about anything, frankly. And of course, you're meeting your continuing disclosure obligations for your publicly held debt. And if it's parity, you're informing the investor in the bank loan and the publicly held debt. And so I think putting the document itself on Emma, which, as most of you know, and I think we're going to touch on later, has a more user-friendly mechanism for doing that now than they did a few months ago. I don't know. They're going to the blowback for finding out through the disclosure. It's just postponing the inevitable anyway, because it's going to show up in your audited financial statements at some point, and it's going to show up in your own continuing disclosure update for public investors at some point. So why not hear about it sooner rather than later?
Renee,
Great suggestion. Thank you, Renee.
Renee, Dave Erdman from the state of Wisconsin. One observation I have, I did a bank loan back in 2014, and you talked about the additional capital costs that could be included, in the documents. I mean, I was alarmed when, in our transaction, in the term sheet they sent to us, not only do they want capital costs going forward, but if there was a change in that area, they wanted the ability to go back 180 days and charge me for costs going backwards. Is that still the norm in the documents, or have banks gone away from the look-back or the catch-up period for some of those capital costs?
So you'll see a catch-up for when it was effective. Is that what you're talking about, sort of the effective date? Yeah.
Yes.
No, that is fairly standard. And I think, if Congress really is getting serious about tax reform, and some people think corporate tax reform is more likely to get done than individual tax reform because the politics are a little easier and there's more consensus about the goal of lowering the nominal rate and broadening the base, that could be something that does become real for this bank loan market, and it's something I think is worth focusing on. And as I said, try and get the right to prepay the loan should that happen, and then at that juncture you can shop around, and maybe at that point the public market is better, and you take out the bank loan. Any other questions? Okay, so I'm going to hand off to Peg, who's going to walk us through what GFOA has to say about this territory. Peg?
Okay, thank you. Well, GFOA has a best practice on understanding bank loans. Many of the things in this best practice we've already discussed on this webinar, but let me go through them briefly. First, they recommend developing policies and procedures on the legal and financial aspects of using bank loans, becoming familiar with various types of terms used in bank loan documents, understanding how bank loans are treated on financial statements, and understanding the types of disclosures made about bank loans, assessing whether state and local laws permit bank loans, and consulting with financial advisors and legal counsel. Can we move to the next slide, please? So specifically, GFOA recommends asking the following questions about bank loans, many of which Renee just covered. Is bank qualified debt or other public debt a better solution than a bank loan? Does a bank loan apply against a government's debt capacity? How will the bank loan provider be solicited, evaluated, and selected? Is the bank loan fully amortizing or a bullet? And what is the debt service structure? Are there restrictions on issuing additional debt? Does the bank loan have priority? And is the interest rate risk of variable rate debt manageable from the issuer's perspective? Could we move to the next slide, please? Finally, GFOA takes a very strong stance in recommending voluntary disclosure about bank loans, especially if the government has other debt outstanding, using EMA or issuer websites. Now, depending upon what the SEC does tomorrow in proposing amendments to 15C212, this may no longer be voluntary in the sense that if they add disclosure of bank loans as a type of event that has to be disclosed under 15C212, if the issuer has any other debt outstanding, that will be, when a bank loan is taken out, it will have to be disclosed. But at the time that GFOA adopted this best practice, there was nothing like that on the horizon. So they recommend particular information be disclosed, whether or not you choose to use this to create a summary that includes this information or whether you attach the entire document. First, the loan amount and the date incurred, final maturity date of the loan, the debt service schedule, the interest rate method of calculation if the debt is variable, use of loan proceeds, legal security and source of payment, covenants, events of default, and remedies. As Renee just indicated, those are things that other investors will be particularly looking for. Also, they'll be looking for term out provisions, payment acceleration, and other non-standard terms, and any other important information. And Renee, I believe you were going to talk then about how an issuer might go about using EMA to make voluntary disclosure about bank loans.
Actually, Peg, I was going to do that. Next slide, please.
Okay.
With respect to disclosure, the MSRB recently has upgraded its EMA system. I think this went into effect in the fall of 2016 to make it easier for issuers to file information on EMA about bank loan disclosures. With this reorganization, it also made it easier for those looking for information to find it. On slide 19, we have a screen print of the EMA screen where now, instead of just financial and operating filing and event filing, you also see an option for bank loan alternative financing filing. Again, this went into effect in fall of 2016. The MSRB has gone back, and if an issuer did do a bank loan financing prior to that time, they've tried to move those filings over to this part of EMA so that people don't have to refile or do duplicate filings. If an issuer has done a previous filing on bank loan disclosures and doesn't see it on the EMA organization underneath this bank loan alternative section, the MSRB has indicated to me that just highlight the items that should be moved over there, and they will go ahead and move those without requiring a second filing from an issuer's perspective. I guess with that, any other questions people may have on this presentation?
And this is Ellen Evans again. Were either questions either on the regulatory front or on the business points that Renee has spoken to so clearly as to how to actually execute this so you end up with a result that not only one that you like, but the one that you can demonstrate is a good result?
One question I have, Ellen, or observation is that the terms and conditions of the bank loan agreement will require that if information is going to be provided, that the issuer redact certain information. And I guess a question for Peg or Renee to address is that, while that may be a term and condition of the bank loan agreement, most of us states have open record laws, which may be difficult for us to redact that information. Are these banks, still requiring that as a term and condition, or they backed off from that redacting requirement that if we do file this and make it publicly available, that we hide the interest rates and other certain terms?
Well, my experience has been that they ask, but don't dig in.
There is
for the very reasons that you just cited, because I haven't been any place where it isn't at some level public information.
There is some precedent, Dave, in that in the context of VRDOs that are backed by liquidity facilities or letter of credit, dealers who remarket those securities are already required to file the letter of credit agreements and the liquidity facilities with the MSRB. And the MSRB did permit a limited subset of that information to be redacted. It'll be interesting to see when the SEC comes out with this proposed amendment to 15C212 what they might say about the topic of redaction.
So again, Peg, to clarify that the SEC's action tomorrow is a proposal, and then presumably the proposal goes through some sort of process if it goes forward?
That's correct. It would be a proposed amendment to Rule 15C212, and so there would be a public comment period.
Well, we will look forward to the announcement tomorrow. Again, the topic is very, very timely, particularly in the context of the SEC's announcement tomorrow. Perhaps this is a good moment for last call for questions. I know that those of us David and I, who have been able to work with Peg and Renee on this presentation, we've learned a lot. It's a really very helpful framework for the regulatory context, and I think an extremely helpful consideration of the business points on the loan documents, on the negotiation of the loan documents. So I thank you for that. Jeremy, do we have additional, or Preston, do we have additional questions that have come in that I've not seen here?
No, I think I've not seen any more come in.
I do understand that there was an issue with the handouts. I'm not sure if that's been resolved yet. Preston or Jeremy, if you want to address that. I mean, I understand that these will all be available in the archive at some point, but can people access the handouts at this point?
I have not been able to test the handouts, but the presentations and speaker bios will be available on the NAST and SDMN websites in their respective webinar archives, along with the video recording after the presentation.
Well, thanks to all our participants for your time this afternoon. More importantly, thank you, Peg Henry, Renee Boicourt, and Ellen Evans for your time in speaking and co-moderating this important webinar on issuer considerations for bank loans. Again, the webinar committee of the State Debt Management Network will be looking to prepare other webinars for later this calendar year, and if there's any topics of matters that people are looking for to include as a webinar topic, feel free to forward those back to the State Debt Management Network. With that, thanks again, everybody. Goodbye.
Thank you, David.
Bye-bye.
Thank you all.